Facebook. My name is Rochelle Manderson and I'm one of the solicitors here at TBA Law, and if you've been keeping up with our TBA Law Facebook page, you'll know that today is Facebook Live Day, and today you have me. Now, what are we talking about today? We are talking about horses. Unfortunately, I couldn't bring in a cute pony or something to make things a bit interesting, but it is going to be an interesting discussion that we're going to have. I forewarn everybody out there that we are actually using a different phone today, so very much hoping that it works. If it does not work, I apologize. However, if it does not work, you won't hear my apology because it has not worked. However, let's think positive. Now, anyone that knows me will know that I've got a few passions. One of my passions is animals. So I have a passion for civil litigation, I have a passion for property, I have a passion for helping people, and I have a passion for animals. You will recall my last Facebook Live we did was all about domestic animals like cats and dogs. So we're talking horses today, and we're talking specifically more about agistment and what can happen when things go wrong. So, out in the country, beautiful Nagambie morning, bit chilly, but there's plenty of land out here, there's plenty of paddocks, and there's plenty of horses. And you might have horses for all different sorts of reasons. Horses can be anything from a business, someone's in a business, it could be breeding, it could be racing, it could be showing, it could be all those sort of equine sports going on. And it could also be just for pleasure. A lot of people have horses for pleasure. And then of course there's a lot of people that ride horses or that are involved in horses that can't keep horses themselves because they don't have the land. So they may have to agist their horse elsewhere on properties very much like the properties that we're surrounded. So you might be someone that offers agistment from your property and has other people's horses. You might be someone that is agisting your own horse, and this is going to be important for you as well. Or you may be somebody that owns property, but as part of your business, you might be agisting horses or having your horses agisted for, say, breeding purposes, if you're in various industries where you might agist the horse while it goes to be mated or whatever the correct terminology may be. All this being said, there's quite a few things that you need to know legally about horses and agistment, because everyone knows, maybe not, but generally speaking, you've got your general common law rules about liens and those sort of things, and you've got your general legislation about livestock and animals and those sort of things, but horses are dealt with a little differently. They're not just dealt with like your cattle and your sheep, they're dealt with specifically as horses. So this is where we need to discuss them. You will notice that I'm actually sitting down because there's a few specifics I want to go through today, and so as not to miss anything, I do actually have notes, which I know normally you don't see me with notes. I'm going to use notes when I'm talking about the specifics today because I want to make sure that it is absolutely accurate and nothing is missed, because it's very, very important. It is a specific procedure that is set down in the legislation. So it's really, you might be talking legislation, but it's very important and it's really interesting, so stay with me here. We're talking Impounding of Livestock Act, and we're talking section 24, that's specifically the section for horses. So if you're interested in this area, you can always jump on Mr. Google and you can look that section up. It's quite lengthy. There's an entire part on horses. So if you're in the industry, it's a really good idea, if you haven't already, to actually A, have a look at that part of that legislation, and B, have a good relationship with your solicitor. Your solicitor will be able to assist you in drafting up agistment agreements, which are going to reference this specific legislation, and also assist you if something goes wrong. Meanwhile, if your horse is being agisted and you need some advice because something's gone wrong, again, you're going to want a good relationship with your solicitor so you can have a talk to them, because it can end up in court and it can get quite nasty. So, we're talking Impounding of Livestock Act. You should have an agistment agreement. If you're agisting horses, if you're having your horse agisted, you should have a written agistment agreement that goes through everybody's legal requirements, liabilities, and what needs to be done. both parties should be signing this, and this is very, very important. And this agreement needs to be consistent with the legislation. So essentially what will happen is if a party defaults under their agistment agreement, they have 14 days to remedy the default. What does that mean in plain English? That means that, say for example, you're adjusting your pony. You need to pay monthly your adjustment fees. For whatever reason, this month you don't pay your adjustment fee that's owing. You're now in default because it was your requirement under that agreement that you are going to pay a set amount on a regular basis that's been set down prior to putting your horse or your pony on that property, and you're now in default. Default means you've broken the agreement. Okay, so you've broken the agreement. You've got 14 days to remedy that. Remedy means fix it. So you've got 14 days to say, oh, I didn't pay my adjustment fees, they were due. Okay, I've just got my pay. I borrowed some money from somebody or whatever, and I'm going to pay my adjustment fees within 14 days, and you're fine. All goes on. If you do not remedy your default, so you do not fix the fact that you haven't done something that you're required to do under the adjustment agreement, that's when you need to be aware that you could be served with a notice of default. If, flipping that around, if you are the person or the organisation who is offering the adjustment and you have a client who is in breach of the adjustment agreement, so they've defaulted, they haven't remedied the default in 14 days, you can serve a notice of default on them. And this is where I'm going to refer to my notes to make sure that we get all the information down pat, because the legislation specifies how a default agreement must be drafted, what information must be included, and how this must be served on the defaulting party. Served means given to or delivered to. So, essentially, you must state the owner of the horse is in default of the adjustment agreement. You must give the details of the default. So, payment due on blah date of this amount wasn't paid. You must inform the owner, so that is the person that's in default, of the horse, that when you're issuing a default notice, and that you will hold a lien over their horse. Now this is important because this default notice is going to create what we call a lien over the horse. What's that, you say? A lien is a right over the horse, and it can be very serious because if the default is still not remedied when you go through this process and you have a lien, it means that you have the right to then sell the horse to recover your money that you're owed. You can have liens over all sorts of things. You can have a lien over a car if you haven't paid your mechanic's bill, those sort of things. Solicitors can have liens over documents. There's all sorts of situations, but this is specific to horses. All right, so you're with me so far? Good. Now, you need to inform the owner of the horse how they can recover possession of the horse, including the amount that is payable to the adjuster, or the person that has the adjustment agreement and has the land, the rates of any adjustment fees, and how they can obtain details of the amounts payable. And that you also must state that you can sell, exchange, dispose or destroy the horse after 28 days from when the notice is served, and that of course you can do. You need to specify when the notice was taken to be served, that is when it was delivered, and then the date. Then obviously you've got to have a date of the issue of the notice, so the date that you actually do the notice on. So it must be served personally, or it must be served by registered post. What does that mean? That means that you've got your default notice, it's dated, it's signed, it goes through everything it needs to have under the legislation. And if you're not sure about this, you could talk to your solicitor about drafting it for you, or if you've drafted it, you could give it to your solicitor to review and say, have I covered everything I need to cover? Then it has to be served, as in delivered personally. That means you have to actually, you or a process server, so someone a solicitor employs to serve documents, has to give it to the person right there, in person. If this can't happen, you can also serve it by registered post. That means you send it by registered post to keep the tracking number, and then also you've got the receipt of delivery that you can do using the tracking number through Australia Post Tracking Services. This needs to be sent to their last known address. You should have their address on your agistment agreement, and you should keep their address updated if they are to move on your record in your agistment agreement. Therefore, you should have this address. Now, what happens if things have got a bit sloppy, or if something's happened, or they've moved and they haven't told you? Because any number of reasons can occur. I mean, the fact that they're in default means something's gone wrong in the first place. So what happens? Okay, you can, if you don't know where their last address is, you can publish a notice in a newspaper that is circulated around Victoria. So don't just put it in your local rag that doesn't go beyond your little town. One that can, because the person could have moved anyway, so it's got to go. So one of your main state newspapers is where you put the notice. There's, again, the legislation has specific requirements for the notice. So again, you need to know these, or have a solicitor draft or review it for you, so that you make sure that your notice complies with what it has to comply. Because if we continue down this path and you end up selling, destroying, or otherwise dealing with somebody else's horse, you need to be able to show that you have passed every one of these steps, so you yourself are not legally liable and you have a legal lien over that horse to do what you're about to do. Yep. So it's important stuff. All right. Now, the owner has 28 days. 28 days to remedy the default. So they get their default notice. They've got 28 days to, again, remedy means fix it. They've got 28 days to fix it. They get their default notice and go, oh gee, I owe 10 grand to these people. Then you've got 28 days to pay up, basically. All right, so this is on top of the 14 days you've already had beyond the initial default time. So you've got time. So during this time, during this 28 days, the holder of the lien, which is the person that is adjusting the horse for the owner, under the adjustment agreement, has the horse in their possession, has sent the notice of default, and therefore holds the lien, they need to return the horse to the owner if the default is remedied. That means if the amount owing is paid, or in the situation where there is more owing than 3 months worth of rent, or adjustment fees, 3 months worth is paid. So for example, if you have to pay, if it's $3,000 a month, for easy numbers, to adjust your champion thoroughbred on greener pastures, you need to pay the $3,000 a month. If you don't and you fall behind, the person that is adjusting the horse for you can go through this process. Say for example you are 4 months behind, so you owe $12,000, and you're served with a notice of default. If you pay the equivalent of 3 months rent, which is $9,000, or 3 months of your adjustment fees, then you have that essentially they will release the lien. So depending on how much you're owing, or say for example you're only 1 month behind, you pay the $3,000, and that's what you need to do. But you can also be liable for additional expenses. So additional expenses from the date of the default notice, so the date of the notice that we've talked about that gets sent, from that date, 60 days beyond that date, or the date that the lien is extinguished. So the lien can be extinguished in a few different ways: by paying the amount owing, or paying equivalent to 3 months adjustment fees, or by the 28 days going through, nothing happens, nothing is remedied, nothing is fixed, and then the horse is destroyed, sold, given, whatever it might be, and that will also extinguish the lien. So, and reasonable expenses incurred in the sale of the horse. So if it goes through all of this, if it goes through all of this process and they've already listed that horse with a horse broker, and that comes with a certain amount of reasonable fees, those fees need to be paid by you to release that lien as well. Okay, so worst case scenario here, the default notice is not remedied. The lien remains. You've got a horse on your property. You have a legal lien over that horse. 28 days has elapsed, which means that you can now dispose of that horse and try to recoup some of your money. So for example, you sell that horse. In a situation where you might be owed $30,000, but the horse is only worth $10,000, that's going to be a little bit different to if you're in a situation where you're owed $9,000 and the horse is worth $30,000. So what happens is that when you sell the horse, give the horse or destroy the horse, in this instance it'll be sell the horse, you get the money that's owing to you plus your reasonable expenses during the default period and the reasonable expenses for selling that horse. You can keep those. If you have got more money than is covering that, it's not just a windfall for you. So if you're owed all up $15,000, including your expenses and reasonable expenses and your reasonable charges for selling the horse, and you get $20,000, you can't just keep the $5,000. That money has to go to the horse owner after you've taken your piece. On the flip side, if you don't get as much for the horse as is owing, $15,000 is owing, but you only get $5,000 for the horse, that means it's then up to you. If you want to, you can then take the matter further and you can essentially sue the owner of the horse for the outstanding money. So you can say, okay, I've got $5,000 from the sale, but I'm still owed $10,000, so I'm going to commence proceedings in whichever court is the relevant court. In this case it would be magistrates, but commence proceedings to recover the rest of the money that I'm owed. And this is a whole new process. You then move away from the process we're talking about now, which is liens over horses, and you move into the process of civil litigation, which is another passion of mine, which has a whole nother process. And stay tuned, because it's very likely that one of these Facebook Lives you'll see me talking about civil litigation process, because I get very excited about that. We're not going to talk about that right now, but that is your other option if you don't get the money that you're owed from the sale, or if you're essentially, the horse is in such a state that you have to destroy the horse or you give the horse away, obviously the whole amount is owing. So it's all going to depend on your numbers as to whether you go further with this and what happens after you dispose of the horse. Now, the only other thing is that you need to keep for 2 years your records of the default, your records of the housing, feeding costs, all those things. Keep those records, because if anything happens that the owner comes back and tries to challenge what you've done, you need to keep those records by law under this legislation. And so store them in a safe place. So that's horses, that's liens over horses, that's agistment, and these situations can crop up far more often than anybody would think and than anybody would like. So what's important is to have a good understanding of the agistment agreement, have an agistment agreement, have a good one, have it reference the legislation that we're talking about, and use it, and make sure that from both sides you understand what you're signing. You also need to have a good understanding of the legislation if something goes wrong. So in that situation, you know how to act correctly so that you have a lien over the horse is legally binding, and is because if you don't do the process properly, you can then be liable for selling or destroying the horse because the lien is not legal. So it's important that you know that. So have a good relationship with your solicitor and have a good agistment agreement, have an understanding of the legislation, and try to keep updated records of the if you're the agistment provider, keep updated records of the horses that you have and their owners and where their owners reside. And if you can keep a relationship going with those owners, it can often help not come into this situation in the first place. If you are the owner of a horse that you have agisted, just keep regular contact with your agistment provider, understand what you've signed, understand this legislation, make sure that you diarise anything that you need to do under the agistment agreement so that you're not in default. If you do become in default, you need to remedy that default. You need to speak to the agistment provider so you don't ultimately lose your horse or your pony. And then this whole process can often be avoided, but surprisingly enough, it does happen quite often. So it's something that you should, if you're in the industry or you have a horse yourself and you're needing to register or you're going to offer agistment, you might have some land, it's something that you really need to understand and take heed of, and just be aware of the law so that you can follow it and abide by it. So I hope this was helpful for you today. Unfortunately, I don't have a pony over my shoulder, but with any luck, the information I've given you is interesting and engaging enough to keep everyone interested. It's going to be information that's going to be relevant for some people and not relevant for others, but it is important if you're in the area to know that, and that I do hope you've enjoyed it listening to this today. I'll finish up now. I'll say thank you for your time in taking to listen to me and to listen to this part of advice. Here at TBA Law, we often will draft up agistment agreements for people. We'll often help people with default notices, and we'll often help in any of these processes. So if you're in this situation or if you're in the industry and you'd like to have a good relationship with us, you're always most welcome to call us, or if you're in another area, talk to your solicitor about whether or not they are, again, it's a bit more of a specialist area, so talk to them about if they're aware of this and if they can help you with it, because it can often be a huge asset if you can even just have the basics explained to you in these situations. But other than that, hopefully you'll never be in this situation, but if you are, best of luck with it. And other than that, enjoy this lovely, well, it's a lovely sunny day. It's a little bit chilly, but it's a nice day. So enjoy this lovely day. Enjoy your long weekend coming up, and we will see you in a future Facebook post. Thanks for listening.